Good afternoon and welcome. Thank you for attending our webinar today on understanding Australian visa options for partners. This is part one, in which we are going to talk all about the visa, the different visas that are available, the criteria for those visas, some possible strategies, options, and evidence. So we have quite a lot to get through. Part two will be about the sponsor, and that is about a 25-minute recording that I have made, and you'll be given access to that later. So let's get started. In this section about the visa, as I said, we're going to talk about the different options, and the goal is that we can provide you with information that is correct and will allow you to submit an application that is decision ready and approval ready. So my name's Sarah Gillis, and I've been working as a migration agent for over 25 years. So I've seen a lot of things over those years, and I believe that I have the knowledge and experience that can offer you some value today. As for you, you are in the right place if you aspire to living a great life in Australia and you're motivated to do what it takes, because it isn't always easy and there are often hurdles. So that motivation is key. And of course, you are in the right place if you want to get the right information that will guide you in relation to your own circumstances. So by the end of today's session, you will understand who is a partner and what visa options are available. You'll hopefully identify a strategy that will suit your own circumstances, and you'll have an understanding of the evidence you need to ensure your application is approval ready. As you possibly know, processing times on the partner visa applications can be very long. So the last thing you want is to wait 1.5 to 2 years and then find you're in trouble. So getting the right information from the beginning is going to be very helpful for you. Because the goal is the golden ticket, which is your Australian visa. So we always keep that in mind when we're processing applications, and you should also keep that in mind, that that's what your goal is, to achieve the outcome. There are 3 streams in the partner visa program. One is the engaged stream, so for partners who are engaged to be married but not yet married. Then there's the marriage stream, speaks for itself, where there is a lawful marriage between 2 partners, and the de facto stream. Now, each of these streams have some common features, including that the visa applicant needs a sponsor, and that sponsor will be an Australian citizen or permanent resident. Another common feature that there are 2 steps in the process. In fact, for the engaged parties, there are 3 steps, but the 2 main steps are that the visa applicant will obtain a provisional partner visa, and then 2 years down the track will be eligible for the permanent visa if the relationship is still continuing. Another common feature, of course, is that the relationship must be genuine and continuing. So let's dive in and look at these 3 streams. First one, the engaged stream. Happy Valentine's Day, by the way, to all those partners out there for last weekend. Hope you had a lovely day. For this stream, the visa applicant should be offshore at the time of both lodgement of the visa application and grant. Now, since preparing this webinar, we have had news from the Department of Home Affairs that from the 27th of February, applicants for the engaged stream visa, the prospective marriage visa, subclass 300, and the partner provisional 309 visa will be eligible to have their visas granted in Australia. So I'll explain that a little bit more as we go along, but that's great news. So if you happen to be in Australia and have applied offshore for the 300 or 309 visa, you may not be required to leave the country to pick up the visa. But the general rule is that you're offshore for the time of lodgement and grant, things slightly different in the COVID era. Both the applicant and the sponsor must be at least 18 years of age in this category. And there must be a genuine intention from both the applicant and the sponsor to marry within the visa period. So the visa that is granted is a 12-month visa, and with the applicant and the sponsor must marry within 9 months. And the final requirement is that the applicant and the sponsor genuinely intend to live together as spouses after they are married. I'm sorry, the visa is a 9-month visa, and the applicant and the sponsor must marry within the 9 months of that visa. That marriage could take place overseas or in Australia, it doesn't really matter. So the prospective marriage stream is probably one of the more complicated because it does have a number of steps. In the normal case, the engaged partner will apply offshore for the subclass 300 prospective marriage visa. The prospective marriage visa will be granted offshore, and in most cases, the visa holder will then travel to Australia and the couple will marry within the 9 months of that visa. And whilst that visa is still valid and the marriage has taken place, the visa applicant will apply for the provisional visa. After that is granted, and I'm sorry, that could be granted onshore or offshore, it doesn't matter where the applicant is at that point of time, but the 309 visa will be granted. And that's the first stream, sorry. Second stream is where, again, the visa applicant applies for the prospective marriage visa. But the couple marry before there is a decision on that application. They just couldn't wait, or the circumstances were right. So instead of waiting for the visa to be granted and then getting married, they've actually already married. So in that case, the application will immediately be transferred to that of a partner provisional visa, which is great, and that will then be assessed and the partner provisional visa will be granted offshore. The third option for engaged parties is that even though they are not yet married, the visa applicant applies directly for either the offshore 309 or the onshore 820 partner provisional visa. So they apply for the partner visa even though they're not yet married. They marry before the decision, and then the partner provisional visa is granted. Now, the choice between these different options will depend on a range of factors. The location of the parties, are they in the same country or different countries? When do they want to marry? Where do they want to marry? Maybe even can they live together before they're married? So a whole range of factors. And as you can see from the number of steps, the applying directly for the provisional visa is the least complicated, but again, it will depend on the circumstances as to which is the best option. So in each of these cases, the partner provisional visa has been granted, and then after a period of 2 years, the visa applicant can apply for the residence, that is the permanent residence visa. Now that 2 years dates from the date the application for the 309 or 820 was made. So if the 309 was lodged a year and a half ago and has just been granted, then the visa holder will only have to wait another 6 months before applying for the permanent residence part. So that is the engaged stream pathway. Next is the marriage stream. So the applicant and the sponsor should be validly married. Now this might seem obvious, but it's quite important because the marriage should be valid in the country where it is solemnised. So if the marriage took place overseas, the marriage would have to be a valid marriage registered in that country for it to be recognised as a valid marriage in Australia. The applicant and sponsor must have a commitment to a shared life together as a couple to the exclusion of all others. This means that there can be no polygamous relationships. So even whilst a polygamous marriage overseas may be valid in that country, there should be still, for the purposes of Australian partner visa, a commitment to only having a shared life with one other person. The relationship must be genuine and continuing, and I'm going to explore that a little bit more later. And the parties should live together or not live separately and apart on a permanent basis. So as you can imagine, in many cases, the visa applicant may be living overseas and the sponsor may be living in Australia. That does not mean that they don't meet this requirement, as long as there is an intention to live together. Perhaps they have lived together in the past, but currently, because of visa purposes or perhaps for work or other reasons, the couple are not physically living together at the present time. So the pathways for the marriage stream are a little bit more straightforward. The application is made if the applicant is offshore for the 309 visa. The visa is granted and the visa holder can then enter Australia. And again, after 2 years, the partner is entitled to apply for the permanent residence. Now, as I mentioned earlier, if the visa holder happens to already be in Australia right now, perhaps on a tourist visa, the 309 could be granted onshore after the 27th of February due to the new COVID regulations. So in that case, the 309 was applied for offshore, the applicant maybe came on a tourist visa, and the department is ready to grant the visa. That may be granted onshore, and then again the usual case of waiting 2 years to apply for the permanent residence visa. If the applicant was onshore already at the time of application, then they lodge an application for an 820 visa. Again, the department will process that and the visa applicant must be onshore for visa grant and then wait the 2 years to apply for the permanent residence. So if, for example, at this point, the visa applicant is overseas, maybe is stuck offshore at the moment, the visa cannot be granted. The visa applicant will need to be back on shore for the visa grant. The third stream for partner is the de facto stream, and it has many elements which are similar to those of the married and engaged streams. The applicant and sponsor must be at least 18. They cannot be married to each other. Now, in some cases, the applicant and the sponsor may be de facto partners when they lodge the application, but given the length of time that it takes the department currently to process applications, they may marry in between. That is fine. They need to be partners at the time of application and partners at the time of decision. So if at the time of application they were de facto, that's fine, and at the time of decision they're married partners, that is also fine. But when lodging, they shouldn't be married to each other. They also shouldn't be within a prohibited degree of relationship with each other, so not siblings or parent or grandparent or child or grandchild, aunt or uncle. First cousin is an acceptable relationship. Again, mutual commitment to a shared life to the exclusion of all others. The relationship must be genuine and continuing. Again, not living separately and apart on a permanent basis. And whilst this is the same as the marriage stream, the living apart can tie in with the final requirement for the de facto, which is to be living together for 12 months. So there are many situations, but the applicant and the sponsor could be living together from day one for a complete 12 months and then be eligible to apply for the de facto visa. That's not often what happens, and we'll look at some case studies where, for example, someone might meet someone overseas and develop a relationship, and then there might be periods of time where the couple are living separately and apart, but they do already have that commitment to a monogamous relationship with each other, and that period of time that they're actually apart but not permanently separated could be counted towards the 12 months. There are also exemptions from the 12-month requirement if there are compelling reasons, and compelling reasons could include a number of situations. For example, if the couple are not heterosexual and that type of relationship is banned in the relevant country of the visa applicant and the couple have been unable to live together, that could be a reason to not require the 12 months cohabitation. If there is a child involved, if the health of the sponsor is somehow at risk, or there could be other issues in which compelling and compassionate reasons may be available for claiming less than a 12-month period of living together. Another exemption is if the relationship is registered, and this is quite common, where at least one of the parties is resident in a participating state of Australia and the relationship is registered through the relevant registry of births, deaths and marriages. So the only states in Australia which are not participating or in which you cannot register your relationship are Western Australia and Northern Territory. All other states allow you to register the relationship, and they each have their own requirements, which usually include that at least one of the parties is living in that state. Some of the states require both parties to be living in the state. Neither of the parties can be married, either to each other or to anyone else, and certain documentation would need to be provided. So if a couple have been living together for, say, 6 months and want to lodge the partner visa, if they register the relationship, then they can apply without having to wait for the 12 months. The other important fact to note is that the relationship does not need to be registered as at the date the application is lodged. It should be registered by the date the department makes a decision. It's obviously a good idea to have already applied to register the relationship at least, so that that document, the receipt, can be provided to the department. But if the couple are planning to register the relationship but have not yet done that and still apply for the de facto visa, it's important to submit a document explaining that so that the department doesn't pick up the file and instantly reject the application. So the de facto stream, lots of points there. Now the pathways are either that there is a registered relationship or that there is 12 months cohabitation. The application can be made either onshore or offshore, just like the marriage visa. And in that case, again, the applicant should be either onshore for time of application and time of decision, or offshore for time of application or time of decision. except for the new concession. If the applicant has lodged offshore but happens to be in Australia right now, the visa can be granted after 27th of February while the visa applicant is in Australia without having to go offshore to get the visa stamped. And then again, 2 years later, applying for the permanent residence. So as you can see, there are lots of considerations and options and choices to be made when deciding how to apply for the visa. Where are the parties? Are they onshore versus offshore? Even if they're offshore and want to come onshore, can that person get a visa? For example, if your partner is offshore and you want to apply onshore, the partner would have to get a visa to come onshore, whether that's a tourist visa or a working visa, working holiday visa, in order to apply onshore. If that's not possible, then it may have to be an offshore application. Are you engaged or married? And what are the circumstances and the timings around that? Are you married versus de facto? And again, what are your plans? And if you're de facto, have you got the 12 months cohabitation, or are you living in a state where it's possible to register the relationship? So let's have a look at a few case studies where we can explore some of these options. So we've got Angela in Australia on a working holiday visa, starts dating Bruno, who's an Australian citizen. They move in together, and Angela's visa is about to expire in 6 months. Now, she doesn't want to or isn't able to go and do the regional work to extend the working holiday visa. They've obviously got less than 6 months living together, but they want to apply for the partner visa instead of finding some other strategy for Angela, such as going on a student visa or obtaining a working visa or even leaving the country. They want to apply now. So their solution is to register the relationship. They live in New South Wales, so that's easy to do. And having registered the relationship, which takes approximately 6 weeks, Angela applies onshore for the partner visa in the 820 with Bruno's sponsorship. And at the end of her working holiday visa, Angela obtains a bridging visa, which allows her full-time work. So she's allowed to stay in Australia until the decision comes, and she has work permission. Michael and Tom. Michael is a UK national and meets Tom, who is an Australian citizen, when Tom's visiting London. They strike up a friendship, and Michael later visits Tom in Australia, and they decide that they want to be in a committed relationship with each other. Michael has commitments in the UK, so he needs to return to the UK, which he does, keeps in touch with Tom, and they visit each other every few months. Quite a long trip. They go for different holidays together, and time passes. But eventually, Michael's commitments in the UK have finished, so they want to be together, and preferably be together in Australia, because Tom has his own job and is settled here. So Michael again visits Australia, and it has been 12 months since they committed to a long-term relationship, back when Michael visited Tom in the second point above. So it's been more than 12 months since then. So they're going to claim a de facto relationship and apply for the 820 visa. Okay, Frida and John. Frida's from Brazil and she's here on a student visa in Australia. She meets John. John is still married to Mary, but John and Mary have been separated for a long time. It's just that they haven't got around to divorcing yet. Frida moves in with John and commences living in a de facto relationship with him. Frida's student visa is going to expire in some time, and it won't be long enough to allow them to live, for her and John to live together for a period of 12 months. So John goes ahead and applies for a divorce, which takes several months. And once divorced, he and Frida register their relationship, again in New South Wales, and having done so, Frida applies for the onshore partner visa. And again, she will obtain a bridging visa to stay in Australia after the expiry of her student visa until there is a decision on her partner visa application. Veronica and Matt, Veronique from Argentina is here. She did hold a student visa and then applied for an extension, but that student visa extension was refused, and Veronique has applied to the AAT, and that application is pending. And the AAT process could take up to 1 to 2 years. In the meantime, Veronique had met and fell in love with Matt, and they've lived together for a while now. So Veronique is holding a bridging visa, and she's had a refusal in Australia, and that prevents her from applying for a further visa in Australia. So pre-COVID, Veronique goes offshore to lodge the partner visa, and she returns to Australia still on her bridging visa awaiting her appeal. Now Veronique can't travel offshore to her country, but her partner visa is likely to be approved soon. So as I mentioned, the onshore grant will be available, and she's awaiting news that she'll be able to in fact get her permanent residence visa directly, because it's now been more than 2 years since she originally lodged her partner visa application. So there's an example of where this new concession from the government is going to be of benefit. And finally, we've got Nitin and Mary. And Mary is an Australian citizen who meets Nitin when Mary is working in India for a year, and they marry in India, and Nitin applies for the partner visa on the basis of that marriage. Mary's job is about to finish and she needs to come back to Australia, and obviously they don't want to be separated for a long period of time. So Nitin applies for a tourist visa, and currently would also need to obtain the permission to enter Australia, which is available to partners of Australian citizens. So the border restriction would be waived for Nitin as long as he also has the tourist visa granted. So Nitin travels to Australia, and because of COVID, he extends his tourist visa. And Nitin and Mary are hoping that Nitin's visa will be granted before the expiry of his tourist visa, so that he can take advantage of those concessions and won't need to go back to India to wait for the visa grant. Now, there are about 90,000 or more applications in the queue for partner visas at the moment. And this year, up until the 30th of June 2021, the department will be granting at least 72,000 of those visas. So it's frenetic energy at the department right now to get those visas processed, as you can imagine. And it will get rid of a lot of the backlog. And we're hoping that going forward, the processing time won't be as long. Fingers crossed for that. So what we've looked at are the different pathways to obtain a partner visa. Now we're going to look at the evidence that would need to be provided to meet the genuine and continuing requirement, which is a requirement for each of the visa classes. So these are the 4 elements that the department will consider when looking at a relationship and the evidence provided: the financial aspects, the nature of the household, social aspects, and commitment. So what actually does financial aspect mean? Well, importantly, it is not a prescription as to what you should and should not do. What it means is that how you manage the financial elements of your relationship should be explained so that the department can understand this. And you would look at questions such as, how do you manage those financial elements? So do you have a joint bank account? Do you have separate bank accounts? How do you share the expenses? Do you pool your funds to pay for the expenses? Or do you have joint financial commitments such as a loan, or did you both pool funds to purchase a car or some other expensive item? And how do you share the day-to-day household expenses? So as I said, there's no rule how this must be done, but you should explain how you and your partner manage the financial elements. He pays for the groceries, she pays for the electricity, he pays for everything because she's not working. Whatever the situation, there's no right or wrong. So in terms of evidence that you would produce, if you have any joint assets, you'd provide evidence of that. Bank account, if you own property, you'd have the title deeds or the rate notices. If you own a car together, it might be jointly registered. Any of those documents. Same with liabilities, credit cards, loan documents, mortgage statements. And if you share expenses, for example, one person has all the utilities in their name, great, provide those. And if the other party transfers funds to support the payment of those expenses, again, produce the bank statements. Highlighting on the bank statements the relevant transactions and explaining them in a statutory declaration, which I'll get to in a moment as well. Second element is the nature of the household. So what does that mean? It means that you need to explain what your living arrangements are. Do you and your partner live together alone, or do you live at your parents' house or his parents' house? Do you have flatmates? So just to explain the living arrangements. Usually, of course, the visa applicant and the sponsor would share the same bedroom, and that should also be explained. Where do you live? Do you have a lease over the premises? All those living arrangements should be explained. Are there any children that you either separately or jointly care for? Do they live with you? Do they live with you part-time? That should be explained. And, who does what around the house? So who does the housework? Who does the shopping? Again, no right or wrong here, just to explain how it works in your situation. So in terms of living arrangements, you may have a lease in one or both names. If you don't have a lease, or if the lease is in someone else's name, then you could get a declaration from the leaseholder, or you could even get a declaration from a flatmate who can attest to the fact that, yes, you share a room together and you live together as a couple. Your own statutory declarations will also explain the living arrangements. In terms of children, custody documents, joint names on school reports, or other health documents, maybe authorisations. A whole lot of information can be provided for the nature of the household. Often this is called cohabitation, so you'd also look at correspondence you may have received separately or jointly at the address. You can show that you're living together by address on driver's licence, your bank statements, tax documents, many documents will show that you're both using that address as your home address. Social elements. Do you represent yourselves as a couple? Do you go out together? Do you receive invitations together? Have you got bookings for theatre or trips? What do your friends and family think about your relationship? Do they support your relationship? That's not required, by the way, but if you do have family or friends whom you see often and who know that you're in a relationship, you can request that they attest to the quality of your relationship in a statutory declaration in which they will state how frequently they see you, on what sort of occasions, what they witness when they see you together, holding hands, you're affectionate to each other, you support each other. And do you undertake joint activities? So going to the gym, on holidays, parties. Again, for the social aspects, there's often many types of evidence that you can provide. So anything where you've produced your names out there in the world as a couple. So travel bookings or next of kin notification with your employer. Could also be naming on the will or in the superannuation. You might both have memberships to the same club. Photos are good. They shouldn't just be the two of you. They should be at other identifiable locations. So, for example, in front of the Eiffel Tower when you have visited Paris, or with your friends or family at a function. And remember to put the dates and the names of the people on the photograph so that the department can understand what that's about. And as I mentioned, you can also get statutory declarations from friends or family. Usually 2 or 3 is sufficient, but it will depend on your circumstances. And the declarations should only be obtained from people who have witnessed your relationship firsthand. So they've been to your house, they've seen you together as a couple, they've been out with you. It shouldn't be someone who has heard from someone else or that you're in a relationship, or someone you've just spoken to over the phone overseas and you've told them that you're in a relationship. No, it should be someone who, with their own eyes and ears, have witnessed your relationship. And the final element is commitment. So what does this mean? It means explaining all about your relationship, where it's come from and where it's going. So how long have you been in the relationship? How long have you lived together, and why did you decide to live together? Do you provide companionship and emotional support to each other? So have there been times where situations have arisen, such as job loss, death of a family member, where you've had to support each other? And do you see your relationship as long-term? So what are your plans for the future? Short-term, long-term? For the commitment evidence, there's usually not a lot of documentation that you can provide, but the statutory declaration of the applicant and sponsor are key for this element. You may, though, have travel plans or wedding plans. You may have documentation about that. Otherwise, you can mention that in the declaration. You may also have named each other in your wills or as superannuation beneficiaries, and that's an indicator that there's some long-term commitment to the relationship. So I've mentioned several times about statutory declarations, so I thought give you a bit of an outline of what you can put in your applicant and sponsor declarations. Now again, these will be detailed but not overly long, 2 to 3 pages maximum, and they should be succinct. And please remember that there's a person who has to read it at the other end. So it should be nicely written, preferably typed, and with a nice logical sequence. So that would include how, when and where you met, and maybe who else was there at the time, because you may obtain a statement from that witness, and how your relationship developed from there. And this is not just purely we went out on 1,000 dates together, but how the emotional side of the relationship developed as well. And what attracted you to each other? So what do you love about each other? What do you enjoy doing together? You should state when you started living together, why you decided to start living together, why you decided to get married. And then you can go to town with the who you socialise with, all those fun activities you do together. You can mention those in detail with the names of the people, the locations, how frequently you see your friends. You know, we go to bingo night every Tuesday with Joan and Mary. You should also mention how you manage your finances to make it clear about that financial aspect of the relationship, who pays for what. You know, you may have unequal purchasing power, a financial situation, and if you're living in 2 different countries, then a lot of these elements are not going to be there unless one person is sending funds to the other. You may remember that example of Michael and Tom one from the UK and Tom from Australia, visiting each other, their arrangement was that if you're visiting me in my country, I will pay for all the expenses. If I'm visiting you in your country, you will pay for all the expenses. So again, that just needs to be explained in the declaration. Examples of situations where you've supported each other. Again, who does what around the home and your future plans together. The Statutory Declaration should be on the Commonwealth Statutory Declaration form, which you can download from the Attorney General's website. And as I said, nicely typed, 2 to 3 pages. And obviously the visa applicant and sponsor declarations are going to be quite similar, but they shouldn't be exactly the same. They should be written from the point of view of the writer. And when it comes to the declarations of your witnesses, some of these points will also be there, the socialisation, what they've seen of you together and what they know of your history and what they know of your future plans. So that might all be a lot to take in, and we recommend that you start thinking early about all the options available to you before worrying about the evidence. So the strategy first, evidence second. So there are many options. For example, if your partner is currently overseas, is that partner going to apply offshore and then wait offshore for the visa, or are you going to try and get a visitor visa for them to come onshore and apply onshore? So have a think, but get some advice, because getting that strategy right from the beginning is most important. Then make a decision. When you have several options, at some point of time, you have to make a decision about which way you're going to go, and then commit to that plan. And whilst there's not a lot of room for flexibility, you may need to add that to the mix. For example, when you're going to get married, where you're going to get married, whether you're going to get married or register the relationship. Be flexible and make sure that your application is as strong as possible. And again, with those long processing times, stay motivated. We hope that by 30th of June, many people will be happy to have received their approval for their visa application. But another hot tip is that don't just lodge your application and leave it there. Keep the evidence updated. Lodge your application through your IMI account, through an IMI account online, to make it very easy to upload additional and updated information, maybe every 4 to 6 months, so that when immigration open your file, everything is current and they don't need to send you a big long list of all the actions you need to take. Now, as part of a partner visa, you will need to meet public interest criteria by undertaking medical examinations and obtaining police clearance certificates. For our clients, we always recommend that that is done up front, even though some of those results may expire within 12 to 18 months, because it just means that if your application is picked up by the department, it can be processed straight away rather than going to the end of the queue for you to first undertake those actions. So thinking ahead and getting all your ducks in line is the best way to go. And of course, if you need help, we're here to be your superhero. We take our client on a journey in which we ensure that there are no gaps, so that when the department does pick up that file, they're convinced by the information. The information is simple, it is comprehensible, it is not over the top, it is not too much, but it is enough to show that you have a genuine relationship and the department can make an immediate decision. Why would you work with us? Well, here's what we love. We love rules. We love rules because they show us the boundaries, and we're happy to push to the edge of those boundaries as required. They help us unlock our superpowers so that we can get the best result for you. And we love to get it right the first time, definitely. So feel free to be in touch with us. On the email following this webinar, you're going to get an offer for a discount for a consultation with me, because your situation is different from anyone else's. And as I recommended, getting advice about your specific situation and working through the scenarios and prioritising is the main foundation of a successful application. You'll know where you're going on the journey and you'll know what you're going to get at the end. So thank you very much for attending today. It's been a pleasure presenting to you, and I wish you all the best with your applications. If you have an application in the pipeline now, fingers crossed that you'll get a decision soon. Please ensure you've updated all your evidence, and I look forward to congratulating you once you get your visa. So bye for now.